As other countries, whether as colonies or dominions, adopted the common law of England and Wales as the basis of their own laws, so too they adopted and acknowledged the centrality of provisions of the Great Charter to their constitutional arrangements. In the 19th century, British and United States constitutional practice diverged. While the US Constitution was based on enforceable rights of the citizen and on a formal separation of powers, the British constitutional order operated through the supremacy of Parliament on the basis of unwritten constitutional conventions. The British Constitution was seen as deriving its strength from the common law tradition of the rule of law rather than from any Charter of Rights. As the greatest constitutional lawyer of the day, Dicey declared, the habeas corpus acts were for practical purposes worth 100 constitutional articles guaranteeing individual liberty. As Sir Ivor Jennings later wrote, in Britain we have no Bill of Rights. We merely have liberty according to law, and we think, truly I believe, that we do the job better than any country which has a Bill of Rights or a Declaration of the Rights of Man. As principles of democracy and human rights grew and developed in the 19th century, and with the growth of independence movements in the British Empire and of social movements such as the Charterists in the UK, the Great Charter was frequently called upon in support of the arguments for self-rule and social justice. Although the Chartist movement's demands embodied in the 6 points of the People's Charter 1837 ultimately came to nothing. The two 19th century rights documents from what were to become parts of the British Empire, those of Malta and Tonga, were not products of the British constitutional tradition. Indeed, the remarkable complete Tonga Bill of Rights, the first in the Commonwealth, was said to be inspired by a visiting Methodist minister from the United States. The adoption of Bills of Rights in their modern form in the Commonwealth was bound up with the process of decolonization. The United Kingdom ratified the European Convention on Human Rights and Fundamental Freedoms in 1951 and extended its obligation under the Convention to 42 then dependent territories in 1953. The Indian Constitution of 1950 had contained a comprehensive set of fundamental rights, but these were a homemade initiative after independence. However, the European Convention model was adopted as part of the independence constitution of many new Commonwealth members, beginning with Nigeria shortly before independence in 1960. Canada adopted an entrenched Bill of Rights in 1982, and the United Kingdom eventually incorporated the European Convention into UK law in 1998. Thus, the rights tradition, of which Magna Carta was an inspiration, was eventually embodied in the constitutions of most Commonwealth countries, with provisions reflecting the basic right to government under the law that had been confirmed in the field at Runnymede in 1215.